We are going to start with arguments in the case of State of Ohio versus Kristina Folan. It's case number 18CA0096-M. The State of Ohio has waived oral argument, so we'll just be hearing from Ms. Folan's attorney, Mr. Sheldon. You'll have 15 minutes. We've read the briefs and are ready to proceed if you are.
Thank you, Your Honors.
If you need time to get stuff together, go ahead.
Thank you. Good morning, Your Honors. My name is David Sheldon. I represent the appellant Kristina Folan in this appeal from the Medina Municipal Court. As you can see from the brief, there's only one issue before you, and that is whether or not the trial court properly concluded that there was reasonable articulable suspicion for Officer Demetrius of the Brunswick Police Department to stop Ms. Folan's vehicle on the night in question. I've argued therein that there was not competent, credible evidence to support the trial court's decision. Specifically, the officer testified during the suppression hearing that he witnessed Ms. Folan's vehicle drift from one side to the other back to center. I think he said he saw our vehicle drift right, and then back to the center dotted line where the wheels touched the center dotted line, then back to the right where the wheels touched the outermost portion of the white fog line, then back to center.
Never testified that the tires went over those lines?
Correct, Your Honor. So, and the trial judge, the acting judge in this case, actually said in the recitation of his facts and his decision in the entry, said Officer Demetrius testified that he saw the vehicle drift from right to left, I think is what he said in the factual summary before he reached his conclusions of law. So even taking the trial court's factual recitation from Officer Demetrius's testimony, it's drifting. And the applicable codified ordinance that the officer used to support his stop of the vehicle was the Brunswick codified ordinance that describes weaving within one's lane. And significantly, during his testimony, well, in his police report, he never mentioned the word weave or zigzag. And therefore, most of the appellate courts, and I think perhaps this court, I didn't find a case specifically from this court, but most of the appellate courts, when they're interpreting or coming up with the common ordinary meaning of weaving, they resort to the dictionary. And the dictionary definition involves some erratic driving, i.e. trying to avoid a pothole or an obstacle in the road, where you're zigzagging back and forth in erratic fashion. There was no such evidence in this case that Ms. Folan drove her vehicle in that fashion.
There was video, right?
Yes, Your Honor, there was a video. And the video, what's interesting about the video, if you watched it, there's no weaving whatsoever in the video. So basically, he's testifying that before my video activated, which normally they record 1 minute back or from the time they activate the overhead lights, in this case there was no weaving whatsoever on the video. And he even testified that after she arrived at the intersection of 42 and 303, while she's heading westbound, she activated a right turn signal, turned right, and then he said she also weaved after she turned right. On cross-examination by me, he admitted that, no, that's incorrect. She actually did not weave after she turned right. So we basically have a momentary drifting of her vehicle from center to right, to left, to right, and back to center. And I've cited several cases, you've seen them all, the Gregorian case out of the 8th District, the Petaway case. I distinguished the Lish case from this court. In the Lish case, there was repeated or several actions of weaving by the driver, and the driver in the Lish case actually didn't use the left turn lane. So there was a failure to obey a traffic signal or device, i.e. failing to get the turn lane to turn, which distinguishes the Lish case from this case, and that's one of the cases that the trial court used in support of its decision. So even applying the applicable law to the facts, the trial court erred again because the applicable law, the Lish case, does not support the trial court's conclusion that Ms. Folan, or that the officer had reasonable articulable suspicion to stop her vehicle. So, for all those reasons, and I think this is a solid case, where we're talking about an inconsequential movement of the vehicle within its lane that does not justify an officer stopping the vehicle to investigate what turned out in this case to be operating the vehicle under the influence of alcohol. So for all those reasons, I respectfully request that the 9th District Court of Appeals reverse the decision of the trial court in this case in discharging this fault. Thank you.
Questions?
No.
All right, thank you for your argument.
Thank you.
The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail you a copy of that decision on the day it's released. And you can also keep an eye out at the Supreme Court of Ohio's website where the opinions are also posted, as you know. Thank you for your argument this morning.
Thank you.